from the podium for 1 month and make a good presentation for once. And we're very happy today to have Amy Hogan-Simonovich and Jerry Mapleton from Ridge and Downs with us representing the Young Lawyers Division of WCLUB. And they're going to present to us evidence and workers' comp primer. We all need this primer, from time to time. I'm sure you've been in the same position that I've been in, which is, a question, the question comes and you say objection, and the arbitrator looks at you and says, what is the basis of your objection? And you say, it just didn't sound right or something. And that's usually not a good objection. So Amy Lee and Jerry are going to help us make good objections. All right, so here they are. Thanks.
Is that good? Can you hear me? Hi, I'm Amy Lee. Jerry and I are going to kind of take turns here and split this up a little bit. So I'm going to start with some of the basics. First, I know it doesn't seem like it all the time, but the Illinois Rules of Evidence do actually apply before the Illinois Workers' Compensation Commission. So Section 7030.70 of the Rules Governing Practice addresses this issue that the Illinois Evidence Act does apply to proceedings before the Illinois Workers' Compensation Commission. Yes?
So Section 7030.70A contains, and I know this is in the rule, contains some incorrect citations to the Illinois Evidence Act.
It does, and I noticed that I cut and pasted incorrectly today as well, so I apologize for that. I think that might be the wrong one there. Oh, I did? Oh.
It's incorrect and cited in the rule.
So is this right or wrong?
I think this is correct. I think the rule, as printed in the Canada, is correct, but the rule incorrect and cited. The Illinois Evidence Act is not conforming to ICSCFI.
Correct.
But that's what the rule says.
Right. So regardless of the citation there, it does still apply. All right. And the other thing that I think is important that you see in B is that all exhibits should be retained even if rejected. So it's really important that even if your exhibit is objected to and rejected by the arbitrator, that it still does become part of the record for review purposes. And that is because failure to object before the arbitrator does waive any challenge to that evidence on appeal. So if you're going to be arguing evidentiary issues on appeal after the commission, you need to make sure that that is in the record and that's clear for the reviewer. One of the things I came across a lot in doing the research for this presentation is that people made objections during the hearing, but then on appeal kind of tried to frame those objections as something other than what they objected to. So it is really important that you are clear and concise about exactly what your objection is in order to preserve that on review. The second thing that's really important here with regards to review of evidentiary rulings is that it is an abuse of discretion standard. So only if it is that no reasonable person would take the view adopted by the commission. So it's a pretty high bar to overcome on review to say that the commission erred in the evidentiary ruling that they made. So what Jerry and I are going to do today is go through a list of common things that come up with regards to evidence, common types of evidence that you try to enter or that you try to object to that we see a lot in our practice on a daily basis. So the first, with regards to wage records, other business records, oh, sorry, I'm skipping. So first thing when you're trying to enter evidence is you have to ask yourself is it relevant and can you authenticate it? So no matter what your evidence is, you first have to make sure that it is relevant evidence, that it has the tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. You also have to weigh concerns regarding the danger of unfair prejudice by this evidence. So I think those are some really basic rules that maybe we tend to overlook. The other thing with regards to authenticating the evidence that's Illinois Rules of Evidence 901. Is the evidence sufficient to support a finding that it is what the proponent claims? What's really important here is that you don't necessarily have to have the witness that made the evidence, right? You just have to have somebody familiar with it to testify that it is what it purports to be. There's other ways that this can be done with regards to other distinctive characteristics and things, but I think it's best that we all focus on making sure that we actually have a witness to authenticate the evidence. Okay, so the first thing on our list was wage records and other accident and incident reports. And I think the most important rule for this purpose is the business records exception to the hearsay rule, which allows in records kept in the course of a regularly conducted business made at or near the time of the transaction. Pursuant to this rule, you have to also recognize that statements made within the business record that are hearsay must also be admissible under another hearsay exception. So just because it is a business record, if it contains other hearsay statements of other individuals, does not necessarily mean that the contents of that does come into evidence under the business record exception. There's, again, no need for the preparer of that business record to testify as long as it is a person in the business that is familiar with the entity's business methods and procedures and can testify to these record-keeping practices. Okay, so if you're trying to get a wage statement in, you don't necessarily have to bring the bookkeeper that entered in the numbers, right? You can bring in another individual from that business to authenticate that document. There's obviously other public records exceptions. I think the most surprising thing with the public records exception is that police reports are not allowable into evidence under the public records exception. So the next thing on the list is getting video into evidence. This is one of the most common things I think we deal with on a regular basis, whether it be surveillance video or video of the accident itself. To get your video into evidence, a foundation must be laid by someone having personal knowledge of the filmed object, that the film is an accurate portrayal of what it purports to show. This does not mean that you need the testimony of the cameraman, and you have to have, somebody that was present, someone that is familiar with how the video was made and kept. Okay. The other thing that you have to make sure that you're considering, again, goes back to 401 and 402 with regards to relevant evidence and unfair prejudice. One of the cases that I cited for you today was Carroll versus Preston Trucking. And the reason that I cited that case for you is I feel like it's a common thing that I see regularly in my practice when it comes to surveillance video and questions about whether or not that video was edited. And in Carroll versus Preston, they kept out an edited surveillance video because it had been edited, and the judge did find that that was unfair prejudice. The objection was that it only showed short periods of time when the plaintiff was actively participating in yard work. The recording stopped when the plaintiff went inside his house or left the cameraman's range of sight, giving the impression that plaintiff's activity was constant, that he could sustain labor-intensive activities over a period of time without rest or without experiencing pain. And in that case, they did hold that it would be unfair prejudice to allow that video in its edited form without the full footage. One of the things that comes up a lot with regards to surveillance video is the idea that there's no discovery in workers' comp. So as petitioner's attorneys, in my experience, how do we get our hands on that video so that we're not surprised by it on the day of trial? One of the things that usually crosses my mind is, can I meet the requirements to do a 19B1? So that is a question that I would raise to all of you to think about. Video of the accident itself, again, it's similar in terms of testimony that the operating condition of the equipment, right? How is this video maintained? How is the video of the premises kept? who maintains the video, who maintains control of the video, was the video edited, can you establish that it was actually the day and time of the alleged incident? So having someone from the employer who can actually testify as to the operation of the video equipment on the site is going to be really important to getting that video into evidence. Here's some photographs.
Hey, Jamie, hi, everybody. You would actually get a podium, doesn't make me feel short for once in a while. Can everybody hear me?
No.
Yep. No. Now, the microphone makes me feel short, the podium's fine. Can everybody hear me? Yes or no? Yeah. Great. I need both hands. Okay, so photographs. Again, we're going to want to remember the three basic threshold questions that we talked about. Is the photograph relevant? Can I authenticate it? And is it overly prejudicial? Well, we know that photographs can be useful. They can talk about a scene of an accident, machinery used, tools, conditions of property, and showing an alleged defect. Other purposes as well. But in order to get a photograph in, you need a witness that's familiar with the scene of whatever's portrayed in that photograph. The photograph needs to fairly and accurately show the scene or object as it is depicted, as it appeared on the relevant date. We'll talk a little bit more about the relevant date in the case that we cite Piekowicz, which I'm probably not pronouncing correctly. Is it here? All right. But we also remember that the probative value cannot be outweighed by the prejudicial effect. The photograph will assist the trier of fact in understanding the testimony. Again, read that Piekowicz case. It's got two interesting aspects to it. One was that the plaintiff was impeached by the records that he put in himself, and two, that the exact date of the photograph isn't particularly inflexible, meaning that so long as the date of the photograph isn't offered to confuse the trier of fact, and that the person offering that photograph acknowledges the disparity in dates, it can be in. So, moving on to social media. This is always a fun one to talk about. You all know what it is. It's Facebook, Instagram, Twitter, or for more boring people, LinkedIn. It's everywhere now, so it can be a really great resource. One of the reasons why is that most of these posts have dates, times, and locations associated with it. We know that an workers' conflict can be used to confirm or refute facts, deal with accidents, notice adhering to restrictions, and permanent partial disability. You can learn about somebody checking in at a certain location at a certain date and time. You can see somebody posting pictures of attending events, performing certain tasks, perhaps tasks that are above and beyond their restrictions. People will post about being at work, being at home, exercises they're doing, marathons they're running, powerlifting competitions they're going to or participating in. But how do you get it? One important thing to remember is that you can't just subpoena Facebook or Instagram asking for content from somebody's account. The Stored Communications Act prohibits, quote, disclosing the contents of an account for any non-government entity pursuant to a subpoena or court order. So you're going to have to do it the old-fashioned way. Another issue that we've noticed is that Facebook may give you some information pursuant to a subpoena, but you're going to have to jump through an extra hoop. Facebook will only respond to a California subpoena, a federal subpoena, or a subpoena that's been authenticated in the state of California. Mark, did you were shaking your head? Okay. All right. So, like I said, you need to get it the old-fashioned way. And you need to scour public posts. They need to be public posts. You cannot send a friend request to somebody under the auspices of trying to relay some new information here. And this applies across the board to both parties. This isn't something that just an investigator or a defense counsel or an insurance company may do to find against a petitioner. A petitioner's counsel may do it to find fact witnesses and impeachable information of fact witnesses here. But it should be noted as far as an ethical consideration, this may more apply to petitioner's attorneys that advising your client to delete posts may give rise to a spoliation of evidence claim, or the negative inferences that arise therefrom. But how do you get into evidence? You have to authenticate it, obviously. And that can be done by direct or circumstantial evidence. You need to give the evidence that the post is what it claimed to be. And even if the social media post is used for purposes of impeachment, it still needs to be authenticated. Again, it can't be, it must be relevant and not overly prejudicial. Let's see. But as the slide here is going to talk about, you still need to be careful because fictitious posts and profiles do exist. So the profile itself may need to be authenticated. Anybody can establish a fictitious profile under any name. The mere fact that a profile is password protected doesn't establish authenticity. So what if the alleged poster at trial doesn't admit to making a post? So you've got to do that circumstantially. You have to prove characteristics similar to other posts that they've made, or you have to get the metadata. And you're going to have a lot of subpoena issues getting metadata, and you could have a whole, we could talk about an hour about the issues in getting metadata into evidence, because again, you're going to have a lot of subpoena issues getting that from the ISP. One of the cases that we cited, which was attached in the handouts, is in remarriage of Miller. Now, this is an interesting case in a family law matter where Facebook posts were offered into evidence over hearsay, foundation, and lack of probative value objections. These were posts of pictures of an ex-wife and a purported cohabitating boyfriend or possible husband doing various things together. The issue was that because this was an action to terminate spousal support, cohabitating would mean that person was no longer entitled to that spousal support. So the former husband submitted pictures of the former wife together with her new putative boyfriend to establish a cohabitating relationship. The husband alleged that the husband offered a bunch of pictures from social media into evidence. They said that it wasn't hearsay because they weren't being used to prove the specificity of these particular posts. They weren't being used to prove that they went golfing on this day. They weren't being used to prove that they went to this restaurant on this day. But it was more of a cumulative nature. But the court was okay with it. The hearsay objection was overruled, and Mark, did you?
They're trying to prove some kind of ING, so come on. Continue.
You're next. So as for the authentication or foundational issue, again, this can be done via direct or circumstantial evidence. The objection was based on posts from third-party commenters on these pictures. Posts like, so nice to see you two together, can't wait to see you guys, can't wait to do things. But the court noted that there's no requirement in Illinois, there's no foundational requirements in Illinois for third-party Facebook posts. I'm sure that will change in the near future. The court did notice that the probative value of these posts was minimal, but there was no prejudice because there was other evidence that proved them to be a couple. So a couple things to note here. Again, you need to authenticate your social media evidence, even if used just for impeachment. You need to be careful about the prejudicial value of the posts, especially when there isn't a volume of other evidence supporting this claim. Another good case, which I promise I won't talk about briefly, is People v. Kent. In this case, it was a murder trial. Now, I didn't attach People v. Kent, but it's an easy site to find. I can give you the site if you need it. In this case, it's a murder trial. The prosecution offered evidence of a suspect having posted something reading, "It's my way or the highway, leaving dead in the driveway," the day after a murder took place in a driveway. But this was discovered by the detective, and the state or prosecution gave no other evidence to authenticate this post. So it was admitted at trial, a guilty verdict was rendered, but the appellate court reversed it and ordered a new trial because they held that it was not authenticated by the defendant and there was no other direct or circumstantial evidence proving that this was authentic. So, that's social media. opinions. Some cases need them, most of them do, some don't, if you're lucky enough. Obviously, for our purposes, generally, they are IME physicians or treating physicians, although treating physicians aren't technically experts. But either way, the opinions of a party's IME are hearsay generally, and therefore inadmissible unless some exception to the hearsay rule applies. That's pretty well settled. I don't think any teacher that things like that. Now, a party's IME physician is not per se an agent of the party who hired him or her, and therefore the expert opinions are not admissible as admissions against that party's interest. Expert opinions must also be supported by facts, and they're only as valid as the facts underlying them. Now, a proponent of an expert testimony must lay a foundation sufficient to establish the reliability of the basis for these opinions. If the basis of an expert's opinion are grounded in guess or surmise, it's too speculative to be relied. Now, the next one is, I think, is one of the more important aspects of it. It's discussing Wilson v. Clark. The facts or data in a particular case upon which an expert bases an opinion or inference may be those perceived or made known to him at or before a hearing, if of a type of reasonably relied upon expert, I'm sorry, I'm reading this incorrectly. If of a type reasonably relied upon by experts in a particular field in forming opinions or inferences upon the subject. The facts or data need not be admissible evidence. This is a good way for people to possibly backdoor some information that may have otherwise been inadmissible. Documents prepared in anticipation of litigation are not admissible as business records because they do not possess the same trustworthiness as other records prepared in the ordinary course of business. Now, we'll talk a little bit more about this as it relates to physicians' treating records and narrative reports, but going on, the Illinois Rules of Evidence do not include statements made to a healthcare provider consulted solely for the purposes of preparing for litigation or obtaining testimony for trial. So that dovetails with talking about medical records under Section 16. As we all know, pursuant to Section 16, the records and reports of a claims treating physician, which are certified as true and correct, are admissible as evidence of the medical and surgical matters contained within the records or reports. Now, there is a rebuttable presumption that any of these records, reports, and bills that are done in response to a subpoena are certified to be true and correct. Now, Section 16 does not apply to reports prepared by a treating medical provider for use in litigation, commonly known as a narrative report. One of the more important cases that discusses this aspect is RG Construction Services versus the IWCC. Now, some of the important issues to remember from RG Construction is that, now, the simple fact that a treating record has a causation opinion in it does not automatically lend itself to a hearsay objection being granted. Somebody making a hearsay objection based on the fact that they believe that this opinion is not related to or not normally prepared, I'm going to backtrack. If they're suggesting that this opinion was done for purposes of litigation, you can't just point to an opinion, a causation opinion in medical records and say that's enough. You have to show something a bit more than that. That's what the court in RG Construction wanted to see. You can't just make a baseless accusation that this was done for the purpose of litigation without something to back it up. Now, you have to do that through either direct or circumstantial evidence, by comparing other medical records, where you may run into some HIPAA issues there. But one of the things that the RG Construction Court also noted that when it comes to medical records, they're generally assumed to be trustworthy, and the probability and accuracy and trustworthiness of a document may serve as a substitute for cross-examination. So it's not enough just to allege that a causation opinion is automatically lends itself to a hearsay objection being sustained, but you've got to do a little bit more than that. What exactly I'll leave to salient capacitors, I'm sure. Okay. And I'm going to hand it back over to Amy to talk about gear. And one thing about gear is that it's gear, it's not Greer. I've heard people making Greer objections during taking the Greer definition. It's gear. I don't need anybody to help confuse me or make me look dumb, so just remember, it's gear, not Greer.
I'm sorry some of my colorful slides were not easy to read on the screen. So I thought it was important to address kind of the way that gear has evolved over time. We all hopefully know that GEAR stands for the proposition that the treating physician's opinions or the IME opinions have to be provided to the other side 48 hours before the start of the hearing. In GEAR, the court found that the treating physician's causation opinion would have gone beyond the contents of his medical records because there was no mention of causation in his records or that the physician ever treated the employee for the heart condition at issue. So basically the court found that this was surprise causation testimony that the other side had no reason to believe was going to come up that day. When we go to Holmbright, we see a little bit of a distinction made with GEAR. The Holmbright court found that the employer was put on notice that the treating physician may testify to causal connection because he treated the condition at issue. So what this tells us is there's no bright line rule or presumption that undisclosed opinion testimony constitutes surprise. So if you're going to take the deposition of the doctor who's treating the condition of the injured worker, it's likely to assume that they're going to talk about causal connection. So it's pretty much what Holmbright says. In Kishwaukee, which is kind of becoming my preferred way to handle this GEAR issue, the claimant's attorney sent the employer a letter notifying them that he intended to inquire about causal connection at the upcoming deposition. So this is something that I do regularly when I have a deposition of a treating physician coming up. I send a GEAR letter. I have a standard form letter that I send to the other side saying we're going to talk about these things. So no one is surprised when we get to the deposition that we are going to talk about the treatment, causal connection, all of the things that everyone I think expects there to come up in the deposition. So there really shouldn't be any surprise because this is what we do, right? But alas. The Mulligan case is just important because it talks about the hearing, the arbitration hearing is the start of the hearing for the arbitrator, right? And what happened in the Mulligan case is they had a records review that was obtained prior to the start of arbitration, and they tried to get it into evidence after the hearing had already started and been bifurcated, and then they tried to put in a records review that they were in possession of prior to the first hearing date. So Mulligan clarifies a couple things. First is that once you start the hearing, everything has to be disclosed. You can't show up at the second bifurcated hearing date and try to provide new information and say, well, I gave it to you 48 hours before this hearing date, right? So I think it's fairly self-explanatory, but I've come across it in my practice as well, where we bifurcated a hearing and then, somebody wants to get a new IME or introduce a new records review, and I think it's important that we all know that the hearing has already started and that can't be done. Yes, Mark?
So, I think one of the problems that's resulting from Mulligan and that isn't resolved is a Mulligan overruled the commission decision, I think it's called that held that the hearing begins when the first evidence stage. Mulligan overruled it. And one of the problems that resulted is, of course, as a matter of practice, we all take our evidence tests before we start the trial. And I've experienced a situation where we take the treater's evidence deposition, and then challenge the treaty is being. And that's a problem that's not soluble on the moment.
I agree with you, yeah. So what Mark's talking about is, you know, being surprised with new medical evidence after we've already taken one of your depositions. Because technically your hearing hasn't started yet, so they didn't have to provide it because we haven't started the hearing. And I agree with you, it happens a lot, Mark, and I don't think it is, you know, maybe it's something we'll see, you know, more on in the future, but as it stands right now, hearing hasn't started, so. Okay, so then, yes?
Another quick warning and point of problem for the lawyers. Only here once in a year. I opened the hearing and requested the attorneys so they can present their expert witnesses. We start at 9 o'clock and the issues were complex. We agreed off the record to defer completing the request for hearing. Well, apparently the case wasn't going well for either side, and they set aside that entire hearing because there was no request for hearing admitted before the trial started. Corollary to that is the attorneys that walk out and say they're not going to sign or participate in signing the request for hearing. So it relates to this as when does the trial start? So it's just a warning point for the lawyers here.
So I think what Arbitrator Andros is explaining to us is a warning to make sure that you've actually completed your request for hearing form before you start your hearing. Is that right?
It is signed. I will defer wages and certain things, but to get these experts on, as you know, he's always anxious to try the cases and no good deed went unpunished. So
Okay.
the lawyers, the losing lawyer in that argument, suffered because there was no request for hearing.
Okay.
Till later.
Another one from Mark?
Yeah, just a quick point. I mean, the commission at one time, you know, was flexible enough to permit bifurcated hearings so that you could get the experts' testimony afterwards. I do understand the petitioner can take their witnesses in any order they wish. The commission does not appear at this point in time to prefer the flexibility of permitting the respondent to take their experts' testimony afterwards, and that creates a much bigger problem for the respondent, it seems to me, even though I'm, you know, I love the case. I've represented many, many hundreds of them in my case, in fact, lots of their cases. But that presents a problem for the respondent when they put on their entire case before the trial starts. So maybe some flexibility on the part of the commission could alleviate the problem Mark talks about, because the respondent's entitled to decide too.
Arbitrator
I can
Andros?
solve that shortly. In serious cases, brain injury, heart injury, or when it's not your normal orthopedic case, the attorneys would approach me and talk about bifurcations because of the complexity of the medical issues. Knowing the experts wanted to know all the details, I put the petitioner on first, as long as the deposition dates were within the 120-day rule. And I was always, the attorneys were always very cooperative. Now, if they came in and said they're going to take a deposition 6 months from now, then I'd say, well, let's get a special date 30 days before those death dates for the brain injury, the heart injury, and things like that. So there is a way to do it under the rules, as long as you do it in 120 days. And I think most of the arbitrators that try cases effectively will do that for you. So
Yeah.
another practice is
Okay.
like share.
Case management where is required.
On serious cases with complex medical.
Yeah, not
And cooperation.
That's a big issue.
I agree.
So I only have a couple more left, you guys. I'm sure this is a riveting topic for everybody. So the next one is medical bills. I don't think we should forget that it is part of the foundational requirement that we establish the bill is reasonable for the services provided. I know a lot of times when I'm taking a treater's deposition, this is a question that I will ask so that I know that I'm laying a foundation for that treating physician's bills. You can also, obviously, introduce any testimony of the person having knowledge of the services rendered, that the charges are reasonable and customary. But again, I think in our case it's a little bit different because we do have a fee schedule, that applies as well. So that's going to kind of dictate what the charge ends up being. So I'm not sure, how much that really comes up as a foundational requirement in our everyday practice. One of the things that I found interesting was that there was a recent unpublished case, Meserly. If the objection is not raised, then it's automatically assumed, that the bill was reasonable. So another, it's not a commission decision. Baker v. Hudson found that if the bill has been paid, it's prima facie reasonable. So medical bills, not so interesting. This is a slide who I grabbed from Catherine Dillon. Thank you, Catherine. She recently gave a presentation on how immigration interplays with workers' compensation. I found it really interesting. I put some of the content up there for you in terms of how to address admissibility of immigration status in your workers' compensation cases under the Illinois Rules of Evidence. But again, I'm not an expert in this, so I just thought it was useful reading for you guys to have. Do you want to do evidence of prior bad acts, or do you want to do it? Oh, there. So evidence of prior bad acts, I will admit, is an interesting one. I'm not totally sure I've always wrapped my mind around it. I've had it come up in a couple cases where somebody tries to introduce evidence that the petitioner had been disciplined for something in the course of their prior employment for the employer. One of the things that I think is important to remember under Rule 608 is that it has to go to the character for truthfulness or untruthfulness. So when we're talking about evidence of prior disciplinary action, it has to actually bear on whether or not the witness's, the petitioner's truthfulness. Not just that maybe they did something stupid one time, but it actually bears on whether or not they're a truthful character witness. The Illinois has not adopted 608B, which I think is important in terms of understanding that the Illinois Rules of Evidence and the federal rules of evidence are not identical. So some of us who only studied federal rules of evidence in law school, just be mindful that there are differences with regards to which rules Illinois has adopted. So I think that there's a lot of cases where this information stays out because it's overly prejudicial in terms of its probative value, because we cannot just collaterally attack the character of a petitioner or any witness. We have to be sure that we are actually offering it on the issue of their truthfulness and that it would actually have a bearing on the outcome of the case. So those preliminary questions about veracity and truthfulness have to come into issue before you try to enter in this evidence, and it has to actually bear on a substantial issue in the case, not just that they may have done something random and been disciplined in the past if it's not going to have any bearing on their truthfulness. I don't know. Everybody with me on that? All right. This is another one I will tell you I am not an expert in, but thanks to a recent conversation I had on Wednesday with another attorney, I thought I would at least put the statute and the rules up there because I don't think a lot of us have read through this yet. I certainly haven't. But we're seeing it more and more with the changes to the Act and the intoxication provision that was added in Section 11. There are a lot of rules in 9140.30 in terms of what you have to do to get your intoxication evidence admitted, chain of custodies, you have to follow certain collection procedures, verification procedures. So there's pages and pages in the rules that outline exactly how to do this for various specimens, whether it's blood, urine, or alcohol content. So it's worth a read. I think it's important that everyone takes a look at it. But again, this is another one of those topics we could spend an entire hour delving into. But I just wanted you guys to have that one handy. The last slide is, okay, so your evidence got rejected. What do you do now? Make an offer of proof. Explain so that you preserve it on appeal what the evidence is that you offered, why what you expected the evidence to show and what its purpose is. This will go a long way when you raise this issue on review about trying to get that rejected evidence in. You want to make a record of why you're trying to enter it and what the objection and what you're proposing it is. Okay. Mark?
Just a suggestion. If the evidence that's been rejected is testimony, you've got the witness on the stand. It's my belief that the best way to make your offer proof, if the arbitrator won't permit you to do it, is through question and answer form. And then, if the appellate court has a record of what you're seeking to admit, they can either admit the testimony or not.
Correct. Anybody else have any questions of me before I move away from this podium? Yes, sir?
Quick practice to back of that expert witness. Quick round when we talk about the inadmissibility upon the data or information that the expert relies upon. Many times in the 800 or 900 decisions that I have to issue, the question always comes up, an expert witness in a complex case refers to their written books or treatises. Now we've been out written treatises, but they will pull out Cecil on internal medicine.
I was going to say Campbell's urology.
Exactly. Now, having sparred with the appellate court at their one seminar and being whacked down every year, I asked them,
Lost connection to the internet.
learn treatises. And they absolutely won't, they don't want to hear about it. When you're taking the test, all I share with the lawyers at my pay is be careful what the experts testify to in their reliance on that data. Once you get past relying upon, let's say, Cecil on internal medicine, in a heart attack case, you tend to want to hear the doctors, like if there's a question, testify all about the book. But it's been one of the problems you get to the appellate court. So forewarned is forearmed. So I have to say.
So, great. We're going to need a few more questions to fill out the time here, so please think of some questions.
Ask Jerry.
But before we go on, I forgot to do this last time, so I hope I don't embarrass anybody, but I do want to introduce our most recently appointed commissioner. Commissioner Dories is with us today. Would you stand up, please? Thank you. Commissioner Dories was here at the last program, and it just completely slipped my mind to introduce her, so I wanted to make sure I did that today. Thank you for being here.
Hi, Mark.
This question will prompt some information to get up, and that has to do with the Article 16 record. I think, you have a broad spectrum of information is in treating doctor's records. You will have a to whom it may concern letter that's 8 months after the alleged accident date.
Well, the letter was one more troubling aspect of it.
So there's that, you can pretty much see, well, that looks like it's ready for litigation. He's not seen a doctor for 8 months. And then we have the day after the accident where Jerry comes in, says he got hurt yesterday, lifting 400-pound engine, and his back is telling him this looks like a work-related accident. That's a causation opinion that I think is going to pass muster without much. But what's your experience and the experience of our colleagues here on what's happened to them in the back in between?
I don't know what, they did go to an yeah. I don't know before for people that have experience with it.
Yes, sir.
My point of doctor focuses on treatment from the consulting physician or the other letter. That's why I thought it related to treatment and not litigation.
Let's try and work it through from a real practical point of view, right? Petitioner says, I'm introducing these records pursuant, I move to introduce these records pursuant to section 16 of the Act, and in there are what the respondent considers to be objectionable causation opinions. What does the respondent do in that case? Mark, what do you do? Do you object
I object
to that particular, to like a
Right, this,
particular sentence?
Yeah, this note from this 3 months after the date of accident where the doctor says this is possibly connected to an alleged occurrence that we object to, this was created for purposes of the,
Okay.
it's not hearsay.
So
I don't
do you,
because the
like,
hearsay
well,
problem is alleviated. by the statute.
because in fact, section 16 in and of itself is an exception to the hearsay rule. So it's like the exception to the exception, right?
Right.
So do you feel the need to put in any evidence to support your allegation that it's prepared for purposes of litigation?
Well, it depends on the case. I may or I may not have any evidence depending on what's happened during this 3 months.
Well, I'm sure you wouldn't make the objection if you didn't have the evidence, right? So,
Let's postulate that you didn't talk to anybody about any accident or wasn't having any problem.
So is one of the arguments that you would make is that there's circumstantial evidence that it's prepared for purposes of litigation because it says to whom it may concern, or it says this report is being prepared for purposes of litigation.
Or I think another one is it says, you know, I just read the IME and this is what I think about it.
So
My
do you have,
hypothetical is he goes to a doctor 3 months later, and
so-
I have
so the question becomes, do you think that saying to an arbitrator, I object, an arbitrator, you can rely on the circumstantial evidence that this is prepared for purposes of litigation to exclude that? Do you think, how would you?
That's my objection, but I don't know where I'm going with it.
Well, I don't think it worked very well for them in RG. I mean, they let that to whom it may concern letters stay in evidence,
I don't
so.
like it.
Mark?
So, just to play devil's advocate, if, let's suppose there's a respondent section 12 exam, and the section 12 doctor said, well, I don't think that the surgery being prescribed by a treater is necessary for the following reasons, and he goes through the reasons. The petitioner gets his copy of that report, goes to his treating doctor, and says, the insurance company just had an exam, here's the report, this doctor disagrees with the surgery that you're proposing. The treater then, in his office notes, addresses those objections by the IME doctor, and says if the IME doctor is incorrect, he says that, we shouldn't do this procedure because of X, Y, and Z. However, it's my opinion that the surgery is reasonable for the following reasons. I don't know that that's necessarily prepared for litigation. Now, second,
I mean, it's the doctor's talking about his treatment.
We got testimony here. We got to have some testimony here. Both sides.
he's addressing objections to the surgery that is proposed. Now, second hypothetical
I think he has
is
to testify.
the doctor writes a letter to me, the petitioner's attorney, and says, well, Herbert, here's why the surgery is reasonable, and I disagree with the doctor whose last name rhymes with name.
So I mean, what Mark is
So that
talking,
second
yeah.
situation is prepared for litigation.
Right, I think what Mark's talking about is when a doctor is sitting down with his patient talking about whether or not he should have this surgery, and now you have a patient coming in your office and saying, this other doctor thinks I don't need this surgery, I'm confused about what I should do. I mean, this is a conversation between a patient and the doctor that the doctor is documenting about whether or not, and addressing the patient's concerns about whether or not he needs the surgery. If that's not, the doctor's not answering those requests at the request of an attorney. The doctor's answering those requests from a patient who wants to know what the best treatment plan is, I think is the argument that Mr. Herbert's making.
Yeah, take it one step beyond. Section 16 says that records will be admitted for the medical matters contained therein. Medical matters. So this is a medical matter.
Sounds like a sentence first trial.
So what-
I'm sorry.
Yeah, I think it also depends on what sort of trial and evidence is for. So if it's 19 and it gets besides the hard factual
I'm so quiet today, go ahead.
He goes to the doctor with the report because the attorney gets the report and talks to us. It's intended.
Not necessarily. I mean,
Litigation purposes.
no, what if he's unrepresented and the insurance company sent it to him?
Oh. Gee. It's intended for litigation purposes, 99.9% of the time.
You mean the aggregation?
So, yes.
That's 100%.
This is not going to be a pro se trial. Ever. This hypothetical case. It's not a pro se trial. Let's not.
I'm sorry to address it directly, but there's no question that this frequently happens when people are unrepresented, because that's how you get business.
Well, it's good for you, Mark. I'm not.
You go off that surgery, then they come to us.
Well, yeah, but I mean, it's just, to me, it's intended, it affects the litigation process.
So,
Affecting it and intending
So
it.
I guess the question that we have to answer, right, is whose burden of proof is it to prove that it was prepared for purposes of litigation? So the question is it just something to think about for you respondent lawyers, right? If it's your burden of proof to prove that it was prepared for purposes of litigation in order to get it excluded from the overall, introduction provision of section 16, right? Then figure out how you're going to prove that, right? If you're comfortable with the circumstantial evidence that proves that it was right, then that's great. But think about ways that you prove that it's prepared for purpose of litigation. Chuck, go ahead.
I agree with everything that I usually do, Mark Herper said. I think a question as far as causation can directly be tied to treatment. But we also live in an era where, and I'm not talking necessarily about workers' comp case, every time that my son fell out of a tree or was injured in a basketball game when he was growing up or whatever, I heard from Blue Cross Blue Shield. Every time one of my clients, who might be somehow on some sort of government medical plan, has anything happen, I'm getting a notice from the state of Illinois, Department of Health Services. In this day and age, doctors have to be worried about who they're charging for their services. I think billing has as much to do with treatment and has very little to do with preparation for litigation. And I think that's another basis that these opinions, especially when you have the circumstance where the Section 12 examiner says this is not causally related or whatever.
I mean,
That's my 2 cents.
Chuck is right. On every one of those UB40 forms, and I know they're not called UB40 forms, but on every one of those UB40 forms, there's a box that says, is this bill related to employment, right? Yes or no, right? So that's on every one of those forms. Yes, and I think that's...
So you can have notes that contain quotation opinions and be admitted, being in a separate office note, the treating provider would address the IME report, and that if it is not, will not be admitted. That doesn't mean that the other previous notes, those also notes that just address quotation, they can be admitted too, without being admitted.
You're saying you could admit certain parts of the records and not other parts of the records, like the whole chart doesn't stay out, is that what you're saying? Right, you can redact, you can just redact the objectionable sentences. Right, I don't think the objection is that you're keeping the whole part.
I think that's it. Thank you. Thank you.